Hey guys, the Irish Demon finally back home again. As you can see, I look a bit disheveled. I've been traveling a lot over the past 3 weeks, and I got stuck into a bit of painting and stuff like that today. So I've been really, really busy. Anyway, while I was doing my painting, I was listening to some courts, and I just came across this one. A very belligerent man decides that he's going to do some nasty, nasty stuff. And when he gets into court for it, he decides that he takes issue with the prosecutor saying exactly what it is that it's alleged to have happened. Now, we all know that these guys tend to get a little bit ratty at times, and some judges kind of go with the flow and let it happen. This one, Magistrate Fink, definitely is not one of those. So we're actually going to be hopefully seeing this guy again tomorrow. So keep your eyes peeled for that one, and I will catch you at the end.
Mr. Johnson, I have a phone number for you. Is it all right with you if the court uses your phone number to contact you?
Yeah,
Okay, I don't have any other way to reach you. If you have a address, we're on YouTube right now, so I don't want you to give me an address. But if you have an address, we can get it from you later on, all right? This is State of Michigan versus Ryan Johnson, 24FB 1026. I will appoint the public defender's office. Go ahead when you're ready, Ms. Vergils.
Assistant Public Defender Chelsea Vergil with and on behalf of Ryan Johnson, we would waive a formal reading of the complaint, stand mute as to the charges, and ask to address bond.
All right, whoever's speaking from the prosecutor, is that you, Ms. Barroso? Go ahead when you're ready.
Good afternoon, Your Honor. This is Assistant Prosecuting Attorney Morgan Barroso on behalf of the people. I am aware that you did the swear to, so I would like to place some of the facts regarding this case on the record, just so that the record is clear as to why we're making the requests we are making.
Okay, and reminding you that we are on YouTube, so careful about the things we don't necessarily want broadcast.
Absolutely, Your Honor. First, I would like to make the request that we are asking for $500,000 cash or surety as far as the monetary amount on this bond, as well as a do not go to for the Julie Street address, home confinement with a tether upon release, as well as no contact for the co-defendant in this case, which is one Julius Clay, Kimberly Bullocks, Alan.
I don't know anything, excuse me, wait, I don't know anything about a co-defendant.
There
wasn't one on the complaint, and I didn't hear anything in the testimony, so
I apologize if there was not one listed on the complaint. However, a warrant was written for that this morning. I do not believe that that was part of the swear to. However, it was written. I don't believe that it was that came before you. If Mr. Clay was left off of the complaint, that was an error. There is a co-defendant in this matter.
all right, is his information in the bond form for me to add to lien?
It should be, Your Honor. His name is included in the request for the no contact order as one of the individuals for the no contact order.
Okay, I do see that on here, yes.
Okay.
His name is not on the complaint. Do you want that added?
Yes, please.
Okay, I will make that amendment at your request. Go ahead.
So Julius, no contact with Julius Clay, Kimberly Bullocks, Alan Duva, and Javier Bullocks. Like I said, in addition, or the reason for those requests is because of the nature of this case, as well as the defendant's lengthy criminal history. I do want to emphasize a few of the facts underlying this case in support of our requests. 3 days prior to this incident, the defendant and the victim, Miss Kimberly Bullocks, had an exchange where the defendant conveyed to her that he wanted the minor child in question. When she said no, he said, "I'll be back for him." Fast forward to February 7th, between 3 and 4 a.m., Kimberly Bullock was up feeding the baby when she heard banging on the door. She did not expect anyone there. Neither did Alan Duva, who also resides at the residence. So Alan, who is an elderly individual, went and opened the front door. When the front door was opened, Mr. Johnson and Mr. Clay barged their way into the residence with guns, knocking Alan over. It's unclear if he hit his head or if he was hit with one of the guns, but he had a large knot on his head. Julius then proceeded to hold Kimberly and Alan at gunpoint, and while Ryan Johnson took the minor child from the residence, placed him in a vehicle, and came back in the residence to gather some of the minor child's belongings. Ryan then proceeded to take the minor child to the Victory Inn. At that point, Ryan Johnson and co-defendant Julius Clay parted ways. We still are unsure of Mr. Clay's whereabouts. However, Mr. Johnson was at the Victory Inn in possession of the minor child. SWAT was dispatched there. They were able to safely get the baby out of the hotel, and he was arrested. I do want to emphasize that the defendant has a 2003 conviction for armed robbery, as well as aggravated vehicle hijacking with a firearm out of Illinois. He has an extensive number of B&Es with intent from the 3rd and 22nd Circuit between 2001 and 2002, as well as an R&O and a fleeing 4th from 2002, and 2 counts of home invasion 2nd from 2009 out of the 22nd Circuit Court.
Okay, so,
Lion bitch.
Mr. Johnson, I would advise
Okay.
you not to speak at
Mr.
this time.
Johnson, Mr. Johnson, I don't have to arraign you if you're uncooperative. It's in your best interest to cooperate with the arraignment so your case can proceed. Uncooperative in my courtroom means that you are using profanity towards any person on this call, or that you are interrupting, or in any other way are belligerent and inappropriate in your behavior. You understand?
Yeah, it is. Absolutely it is.
Okay. We'll see you tomorrow. Goodbye. Step out. Defendant has refused to be arraigned by using inappropriate language during the arraignment proceedings. We'll try on, we can try tomorrow. It's a Saturday, I'm working. So if that's something that we decide to do, or we'll do it on Monday. I'm working Saturday and Sunday though.
Your Honor, would your staff mind sending me an email if he's going to be arraigned tomorrow and I'll appear?
You need to talk to the jail about that.
Okay,
Okay.
thank you.
Decision about whether they want to put him in front of me or not.
Thank you.
Okay.
Well, there we have it, guys. As you can see, pulling this kind of stunt with this particular judge, not really in your best interest. Now, he's going to have to appear tomorrow, hopefully. And if he does, I'll be sure to be watching it to catch it for you and to update you on, how everything went or whatever. Now, obviously, the charges are extremely serious. And given the guy's history, that is why, of course, he has a $500,000 bond, and I think well-deserved. I don't know if this guy will get out or whatever. I doubt he has $500,000 to just throw at this kind of thing. And as I said, given his history, obviously you can't use somebody's history to say whether or not they did do something. But of course, it goes to propensity and all of that kind of thing. So as I said, this judge taking absolutely no nonsense from this guy. And, I don't know how he thought that calling his lawyer a lying, you heard what he said, is going to go in his favor. It's not like the judge is going to go, you know what, you got a good point there, bud. So anyway, lads and lassies, I hope you enjoyed it. Definitely stay tuned, and hopefully I'll have the second part of this one. You never know. Maybe he'll behave himself. Maybe he won't. We'll see how it goes. But we'll catch you in the next one in any event. Sláinte.